I'm only going to speak for a couple of minutes and just identify a couple of core points that should be borne in mind when you are discussing these clauses with other people. The first thing, which is terribly important and relates to something that the Minister very kindly said a moment ago, is the importance of balancing flexibility with specificity. This has to be flexible because the scheme has to be made to work in the light of experience. Therefore, we are using two sets of enabling powers so that the provisions of the scheme will be set out in regulations, the funding provisions will be set out in regulations, subject to affirmative resolution to give Parliament proper scrutiny powers, and the scheme itself will be a quasi-legislative scheme made under the first clause in the set of amendments. So you need to emphasize to people that we've devised something that is clear on the face of the bill. These are not skeleton provisions. They run indeed to over 5 pages of detail, but because they use a system of subordinate legislation and quasi-legislation, they combine specificity with flexibility. Therefore, the Minister and the government will know exactly what we plan to achieve by looking at the detail of the powers, but they will have the flexibility to achieve it in accordance with the light of experience as we go. Second point, the Minister and his officials have been enormously helpful in raising specific issues, specific matters, and we have addressed them all. One of the most important points that the Minister raised very kindly at an early stage was the danger of this all turning into satellite litigation, and therefore we have used a number of ways, including the use of tribunals for sharply focused, low-level, swift justice in individual cases. We've used a number of ways of limiting the risk of judicial review and extensive litigation. And we were asked to get confirmation of this from the bar, and a leading planning silk, a leading planning QC, has certified that indeed the risk of litigation is entirely reasonable and entirely controllable, and she has very kindly given us a pro bono opinion to that effect. She has also confirmed my certification that the clauses that we have produced are compatible with the Article 1, Protocol 1 of the European Convention on Human Rights. So, first 2 points, we've met all the department's objections, and we're combining flexibility and specificity. The only other thing I want to say is for about 30 seconds, I'm going to take you through the core components of the scheme so you can see how it works. Number one, the Secretary of State will have a duty to establish the scheme. It is not a power. There has been some chat on social media that the clauses don't work because they're a mere power. They are not. They are a duty, and that duty is enforceable at administrative law. Second point, this is focused on construction and building work that was unlawful at the time. There is no retrospective liability involved in the awards. There is the levy is a construction-wide levy, but there is no retrospective liability. Point number 3. The scheme will operate through application made by blocks of flats, and they will apply to be certified as eligible. And once that has been done, they will then go through to the second stage, which is to ask for an award. So we've deliberately kept those 2 stages separate. So you satisfy eligibility, and then you discuss awards by reference to what is needed in each case. Fourth point, the scheme will have supplementary subordinate regulations, which will be made by statutory instruments subject to parliamentary scrutiny under negative resolution. And again, that is a duty on the Secretary of State, which will be enforceable by judicial review. Fifth, the scheme funding will be dealt with by a separate set of regulations, which, because they involve effectively imposing a tax on the construction industry, those are subject to affirmative resolution in accordance with proper parliamentary scrutiny principles. Again, there's a lot of detail in the enabling power. There is no suggestion that this is mere skeleton legislation. There are 2.5 pages of detail about the funding regulations content. Finally, there will be time for everybody to feed into the making of the regulations under the clauses, but because they are regulations, they can be made fast. We can get this up and running in a small number of months, and indeed the aim will be that the Secretary of State, we say in the clauses, the Secretary of State should aim to ensure that the first grants under this new remediation scheme are made and paid within the period of 1 year beginning with royal assent. That is achievable with the support of the Minister, who has spoken very kindly this afternoon. With the support of both Houses of Parliament, these clauses can be got onto the statute book, and then they can be implemented fast, effectively and efficiently. Thank you all very much for listening.
My product question is, why do they have to pay at all? But I'd want to be able to explain why we couldn't achieve, exactly as you point out, the PolluterPays approach.
So many noble lords, the Right Reverend Crown Prelate, the Bishop of London, the noble Earl Lord Lytton, the noble Lord Thurlow, and also my noble friend Lord Young.
On this, and I will listen particularly carefully to what the noble Earl Lytton has to say about drawing on the polluter pays principle to recompense leaseholders.
If this was taken forward, it would in fact set in place a legacy that would restore confidence and counter the perversity of the race to the bottom in construction standards and the culture of getting away with things if you can, rather than doing a good job and go that little bit further. And so what I'm fervently hoping is that, given the information on the background and the purposes and the mechanics, the government will see fit to incorporate this into the Building Safety Bill as an amendment of its own.
The only comprehensive solution I am aware of is the Polluter Pays amendment already mentioned by the noble Lord Young. And as he has already said, that would require those developers and builders that constructed the blocks of flats that did not comply with the building regulations in course of time of construction to pay for their remediation.
The Polluter Pays approach has much to recommend it. This well-developed proposal has also been supported by several other noble lords, and I too add my support to their plea for the noble Lord the Minister to respond positively to this proposal.
Armour, in your second point in your written evidence, you say that Armour has publicly supported the Polluter Pays principle. It would then endeavour to recoup that money from those who are responsible.
People who have perhaps pushed forward products that aren't fit for purpose, or people who have just constructed badly. That's why we support the Polluter Pays bill, because unlike some other amendments we've seen in the past, which just says leaseholders shouldn't pay, which we absolutely agree with, it provides a route to pay.
Polluter Pays seems to be the only thing, the only suggestion that can go forward.